Welcome to Be My Own Boss podcast. This is episode 49. I am your host, Mike Hruby, and today we are discussing freelancer freedom. We've got a solution. We've had it. It's been road tested for some time. But let's go back to basics and to get started. In order to hold a job, to be employed, you all know this because you all have one, you need a Social Security number. It's very simple. No Social Security number, no legitimate job. Now, the question is, when you want to be self-employed, where's your number? Well, there isn't one. And there isn't one because there's no objective test for being an independent contractor. Absolutely none. In 87 years of federal labor law, there has not been a route that independent contractors can follow to identify their work. Labor law, as far as independent contractors, is just vague word and no metrics. And by metrics, I mean something that you can measure in a very specific way that people understand. Matter of fact, the only thing that's specific in labor law for independent contractors is the penalties. And so it's really kind of a penalty manufacturing machine, which keeps all the different wheels moving, except the individuals and their contracts. So let's say you want to go fishing and catch a bass in Texas. Largemouth, smallmouth, lots of people enjoy doing this. You're going to have to come up with a 14-inch bass in order to keep it. Everything else you have to throw away. So you have to go to your measure, however it is, made of metal, made of tape, made of plastic, cardboard, whatever. It's got to be 14 inches long. But you want to catch a bass in California or New York, 12 inches will do. So you need your tape. And that's the limit. You can catch and fry anything 12 inches or over. You want to go driving. You want to go through a school district, you're going to have to go 20 miles an hour. Your automobile will tell you how fast you're going. It'll tell you if you're going over 20. The cops have the radar, and they'll tell you if you're going over 20. And even your cell phone will tell you if you're going over 20. It changes color. 19's fine. Can't do it at 21. Interstate highway, a little bit different situation, 65. But you know exactly what the rule is. You know exactly how to keep yourself under control. If you want to take an excursion, you can take a random bet. But if you want to work for yourself, however, there is nothing that's specific. The latest law that is now, regulation that's been proposed, it's in law. It's 60 pages of absolute gobbledygook and conditionals and multi-part tests. It is of no help whatsoever in telling a buyer or a seller exactly how to do it consistent with the law. And that's nothing in politics, nothing in law is accidental. It's there on purpose. Labor law needs an objective test in order to accommodate independent contractors. And that's the purpose of this podcast. It's the purpose of the show. It's the purpose of our work of defending self-employment. It's got to be an objective test. Only we can demand it. No one else is going to. You've seen that. But 5 years plus in California of agony. They've made one change and exempted a bunch of politically powerful occupations, nobody else. So that's the future. It's going to get narrower and narrower until they extinguish our careers. You can push back. Half of the workforce is soon going to be in this exact same jam. We've been acquiring millions of podcasters, for example, guys like me doing this podcasting. A lot of people make quite a bit of money doing it. It's very successful. They're all independent contractors. They all work for themselves. No problem there. But that's threatened. Meanwhile, our opponents are shrinking, but they've got a good hand on Washington, D.C., and they'd stand a very good chance of putting some bad legislation through. The only common thread among all of these 80 million people, soon to be 80 million, is their answer to this question: do you wish to work self-employed on this work? And if they say yes, they're independent. They're working as an independent contractor. And if they say no, they should not be working as an independent contractor, no matter what pressure is applied to them. And we have government that'll keep that pressure from being applied. So answering yes to the question, do you wish to work self-employed on this work? The answer is yes. You pass the test. It's as simple as that. But try to find something that simple in federal labor law. You won't be able to do it. And there are a lot of people that are defending that crazy position. So what's the difference? I'm going to hold up, for those of you who are listening, not watching, I'm holding up a little white card with handwritten Social Security number on it. There. This is the test of whether the government will allow you to be employed. It's as simple as that. They give them out to everybody who asks. They give them out to a bunch of people who don't ask, but that's a totally different story. But this is your ticket, and if you pass that test, then someone can, you can be, you have a permit to work, essentially. You can get paid. Now, what's missing is a self-employment identification number. If you had this, you could pass it around as a token. This is, I have my my self-employment identification number. I'm legit. So the buyer knows that he's dealing with someone who actually does want to do the work, because they went to before the government and they said, I choose to work this way. That's fine. You can have both. If you were to do a relative's manage their estate, you'd get a social security number to manage their estate, and it's not for them it's just a federal identification number, but it's in the same series, 9 digits. You can have lots of numbers in this world. You can have it for trusts, you can have it for estates, you can have it for LLCs. There's all kinds of ways you can use this. So we're looking for a situation where the law allows the individual to have a self-employment identification number. And how would you then apply this test? Well, we've tried for a couple of years to write a simple statement that everyone could accept, and that would apply the strength of law to this status. And what I would like to do is, it's only 49 words long. You can do it and be clear and give up none of your rights, existing rights, accept new responsibilities that are limited, and maintain your choice. What I'd like to do is just read this to you slowly and then go back over and analyze the phrases and help you interpret what they mean. 49 words, that's all we're going to do today. So the quote begins, I elect. So the actor is you. This is about you and your relationship to the government. I elect, that's a choice, to accept the following rights and responsibilities, which we're going to enumerate. You're going to accept them both together. This is the good, the yin and the yang, the good and the bad, of self-employment when working as a self-employer. So everything that happens to me as a self-employer comes from this choice that I've made, and I reveal it to the government, and the government records it, and that becomes the record. Then there's a Roman 1, which is, the clause says, to employ myself under my self-employment identification number as a voluntarily self-employed person. There. It's pretty simple. Employ myself. And then Roman 2 is the right and responsibility to engage others under my self-employment identification number as employees or as contractors or any other lawful arrangement if I so choose. You're not forced to hire other people. That's not a test. It's totally optional. You could do it as employees. They could be W-2s. You could do it as contractors. They could be 1099s. Anything is lawful. Anything that is lawful, you can access. And there it stops. That's 49 words. If I so choose is the last clause. End quote. So let's just go over that briefly and see, what does this mean? I, the first word, individual. I elect. You're an individual voting. You're choosing. You're setting down your choice to accept meaning you're saying, put it in my hands. I'm taking all of it. The following rights and responsibilities, taking them together, of self-employment when working as a self-employer. So when I have this status, I have all these rights and all these responsibilities. I accept them together. Roman 1, to employ myself, that's a right. It's inherent. Under my self-employment identification number, that basically says you're going to, follow the rules for being an employer, even though you're the employee and you've got a dual relationship with a dual nature. As a voluntarily, that's a right. You have the right to do it voluntarily. Self-employed, that's your responsibility, person. So you as an individual are saying, I'm going to follow the law, and this is the law that I'm going to be judged on. Roman 2, this is the rights and responsibilities, to engage others, meaning you can grow your business, and if you want, you can bring others into the activities, into the work in one fashion or another. You're going to do it under your self-employment identification number, which means that you will be reporting your relationship with them, and they can be as employees, and that makes you responsible for them, or contractors, that makes you equal to them in regulations, or any other lawful arrangement, if I so choose. So any other lawful arrangement, meaning any other way, current or future, that people can work together. You have access to it if you choose it. And then if I so choose is a right. You have the right to not grow. You have the right to not hire anyone or engage anyone. You can't be forced to. You're not. It's having an SEIN is not conditional upon anything else other than your election. So, again, I'll just whiz through it. Here's your test. You can think if you would agree to this, if they gave you a self-employed identification number, if that would be of interest to you if you follow what's going on. I elect to accept the following rights and responsibilities of self-employment when working as a self-employer. Roman 1, to employ myself under my self-employment identification number as a voluntarily self-employed person. Roman 2, to engage others under my self-employment identification number as employees or contractors or any other lawful arrangement if I so choose. Period. Full stop. That's how you get there. It's a little bit like an oath, but it's not an oath. It's an election. It's just to be clear. And we want to make clear that this statement is your choice. It's a yes or no statement. If you didn't make the choice, you're not an independent contractor. And that can then be entered in, that will exclude your relationship with yourself from being judged under labor law. Under contract law, you're as a self-employer, you're still responsible for your taxes. You haven't gotten anything for free. You haven't poached on anyone else. You're not leaving any rights on the ground. You have chosen, meaning an election, to accept work that is time limited. And this is probably the newest feature that we're proposing for labor law, is that there isn't a category of work in labor law for time limited relationship. That's important. You have it in contract law. Anything you can contract for a minute, you can contract for 1,000 years. It's all in contract law. But the relationship of an individual is who wishes to be an independent contractor is to time-limited work. The time may be set in a different standard. It may be when you finished 42 of them and got them all delivered. But it's the limit is when the 42 is done, or the paintings or the landscaping or whatever, your relationship is dissolved and it's complete. And you're doing it in exchange for money, so this is clearly contract law. You still have the freedom of contract. We're trying to defend that as part of our defense of self-employment. In future episodes, we're going to look at what this law will allow. One of the big things is it allows a mechanism for moonlighting under law. It provides a form of proof to protect your clients from aggravated misclassification by plaintiffs' attorneys and the labor regulatory apparatus in all the states and the feds. It assures you access to national and international markets, even in states that allow, like California, New York, Rhode Island, Massachusetts, the blue states that are making it difficult. And it provides for penalties for impersonating a freelancer. This is a plague upon independent contracting. The California law, the California labor law decision, Dynamex, shorthand, was caused by people who were salts. They were paid to come and go, file a suit, get out of town, and that is beneath the law. They're lying. They lied to get the work. They lied in court, and the law didn't punish anyone for it. It punished all the independent contractors instead. So for future legislation, we're going to be promoting this. You're going to see legislation in Washington. It's been proposed and discussed. There'll be more coming. There'll be many more comments on it. It's incomplete because it still will be subjective judgment, not objective, and not have a measure and not provide a voice and freedom for the individual. And that's what this nation and our labor laws should be about. So with that, I just wanted to say thank you very much. It's been a pleasure being here with you. Like this episode, follow our channel, and sign up for the alerts so that we can reach you in the future ahead of time. And we will see you next episode. Thanks, and bye-bye.